Predmore case. Ms. Predmore's here. Ms. Predmore, of course, come on over and sit next to your lawyer.
Good morning, Your Honor. Craig Miller, behalf of Ms. Predmore.
All right, as I understand the situation, there was a point in time, I think it was August 8th of 2013, correct me if I'm wrong, where I saw in here, it went back and forth as to what happened procedurally on that day. There's a practice that the municipal court uses called submittals or submissions. I think that it might have been a submittal that we used to call a submittal. But anyway, it seems like there's an acquiescence to a DUI and speeding, I think, on August 8th. Is that what happened in the lower court?
Yes, Judge, it was a submittal with a stay out of trouble issue. She completed everything it was to.
Right, and so that's the starting point in time, August 8th of 2013. Seems like the trial court judge, as part of granting probation, put in place the standard stay out of trouble provision. It's a broad stay out of trouble provision. And that was to run, I think, for 180 days or so.
It was to run for 1 year, Your Honor.
It was a year, okay.
179 days suspended sentence.
Oh, okay, so is it, you agree, Mr. Mueller, that if I were to ask the term of probation with the stay out of trouble provision, it'd be August 8th, 2013 through August 8th, 2014 or so?
Yes, sir.
Okay, so then it's suggested that on or about November 21st, so like, I guess, 3.5 months later, something like that,
Yes, sir.
of 2013, Ms. Predmore here was arrested for driving under the influence in Clark County. And so, of course, when you have a situation like that that occurs, it's typical, and it did happen here, that the sentencing court, I think it was Judge Almasi in the municipal court, once it comes to the court's attention that there's an arrest during the term of probation, probably especially if it's an arrest for the same thing that the person's on probation for, the court will have what's known as a revocation hearing. Essentially, it's a hearing to determine whether there's a probation violation, and if so, what to do about it. The court has a lot of discretion as to what to do if they find that, or if Judge Almasi finds that the terms of probation were violated. And so the issue becomes, it looked like there were a couple hearings. There was a revocation hearing, and was there some kind of reconsideration hearing too?
Yes, Judge.
Yeah. And at the end of the day, it seems like in her wisdom, Judge Almasi found as though there was a probation violation, and that's what we're here to discuss today. Okay. The last thing I'll say going into a hearing like this is that, of course, I'm pretty aware, and I looked at again the law that was brought to my attention in any event. Pretty aware of law having to do with what the standards are when a court involves itself with a revocation hearing. I've done a lot of them, probably 1,000 of them myself as a judge over the years. Most of them go back to when I was in municipal court, but I've probably done a good 50 of them as a district judge, covering for other judges that have a criminal calendar. So the way I've always looked at it, I think, is consistent with the law. The question is, in this case, if somebody's got a stay out of trouble provision, the issue would be, was Ms. Predmore pretty much as good as she was required to be under the terms of probation, because courts don't have to give probation. But if they do and they ask you to stay out of trouble, I mean, my view is, I've heard judges say, and I've even said, that at the time of sentencing, I might say to Ms. Predmore, you understand that you have to stay out of trouble for a year. That means no arrest. Even an arrest could be considered not staying out of trouble. It's a pretty general provision, and the question is, were you pretty much as good or not as good as you were required to be, is the best way to say it. I know there's more to it in this situation, but in a general sense, I think that's what this appeal is about. So, Mr. Mueller, go ahead.
Thank you, Your Honor. This is kind of, it turns on an interesting statistical concept of double blind. If you get in trouble once, and then you say, don't get in trouble again, it assumes that the factors that would bring you back before the court are clean and randomly statistically the same again. But that wasn't this case. Officer Fitz, when he fell in behind her as she was driving home from work that night, knew that she had a recent DUI arrest, which now means he pulls her over. When this declaration of arrest on the new arrest was read and written, it was obvious to anybody who handled a case in Clark County ever that it would never lead to a DUI conviction. I informed the judge that this case probably was at best a minor traffic violation, which in fact what it was. We resolved the case as an improper right-hand turn, not coming to a full stop. That was what she was found and adjudicated guilty of. That conclusion was readily apparent to anybody who handled a case ever. Her chemical test was below the legal limit. She got arrested anyway. Her chemical test comes back, or the breath test out in the field is below the limit. The chemical test comes back below the legal limit. Now, that implies a good faith basis.
It was barely below the limit though, right?
Yes, sir.
It was like .07 or something.
Yes, sir, .7. The answer, well, and of course, many lives have been affected by those arbitrary numbers. Now, it's interesting to hear the state or the city ask for, well, it was close enough. No, it's.
Well, here's what I'm thinking on that, and I wanna see what your opinion is, cause to me, it's really, probably the linchpin of the whole situation, all right? Can a judge in a revocation hearing, consider the alcohol in a revocation context, as part and parcel of issues to consider as to whether someone who's on probation for a DUI has been good or not good? In other words, as I look at it, I see that basically it ends up being a traffic case. That's one way to characterize it, because it started with the idea of this illegal turn and what have you. There also was the thought in the transcript I saw that there was a delay in responding to the sirens on the police vehicle, which in and of itself could be an offense. But in any event, what I'm really getting to is, there's a lot of testimony at the revocation hearing having to do with alcohol use. There's a smell of alcohol, there's, and Miss Halbert, well, she's done one of her little check sheets again. It's on page 11 of her brief, and so it gives me a lot of assistance to see what is in the transcript from the revocation hearing that might be relevant. And I made my own notes even on here, but I mean, Ms. Albert has some things in here that make sense. The defendant admitted to having 2 drinks, well, there's alcohol in her system, although it doesn't rise to the level. So again, the issue becomes, it seems like the record to me, Mr. Mueller, is pretty clear that she's got alcohol in her system. All right. I mean, she admitted to having a couple drinks. We know what the results of the test were. They were just barely below the legal limit. And so that's the issue to me. The real issue that matters mostly to me is, can the sentencing judge, now handling a revocation hearing, consider this alcohol use as a factor, an evidentiary factor, to demonstrate that Ms. Predmore here just wasn't as good as she was supposed to be on probation? That's the question.
No, sir.
You don't think a judge can consider that?
If she said, you can't have anything to drink, then yes, then we wouldn't be standing here. Now, the city has the whip hand in most of these negotiations, Judge. I'm always in a position of negotiating inferiority for most of my life, okay? It's just the nature of being a defense attorney. But that's not what they negotiated for. Now, this is a bait and switch. Now, Fritz is about a 10 or 12-year officer. He's from Austria. Very good guy, very thorough, attentive officer. But he knew before he pulled her over that she'd had a recent DUI arrest. He's got the scope and ran it. That's the problem. And that's where I think the logic falls apart. Now, did she get pulled over? Now, and there's a fine line here. A couple things. This is a traffic offense. The new traffic offense is a right turn offense. Because one of the other things the judge is saying.
Well, it might have ultimately, I'll take your word for it, that ultimately it was resolved with a traffic offense.
And it did.
And you did that?
Yes, sir. It's a.
Seems like you did a good job for your client on that, I'll just tell you. But here's the point of it. In a revocation hearing, though, is the revocation judge limited to only looking at that traffic conviction, or can the judge look at all the circumstances surrounding the arrest,
Yes, Your
including
Honor.
the drinking?
I believe the judge overreached and abused her discretion, and I believe she can't. And here's why I believe
Okay.
that she was in error, that you should sufficiently in error that you should overturn. Number one, when you read the declaration of arrest, you could see, the most unlearned soul could see that this was never gonna lead to a DUI conviction. She was under the breath test. There was arguably not even probable cause to arrest, okay? When she's given the preliminary breath test, it's below the legal limit. When they take her down to the station, she's below the legal limit. The new case was so egregious that it settled as a improper right turn. Now, the city negotiates, they are generally in the whip hand. If they had wanted to negotiate for a no alcohol clause, they could have. We routinely do that. But they did not.
Okay, a lot of things keep coming to my mind, so, you know, I ask them to
Oh,
you.
that's okay.
You don't think if somebody is told to stay out of trouble, that includes impaired driving as well?
Well, first off, there was no evidence of impaired driving. This was, she came up to the stop, didn't make a complete stop, and turned right, and then she saw Fitz pull behind her. She slowed down, creeped over, and pulled into a nice, safe spot. Now, there's no indication that there was bad driving, that she was too intoxicated to safely drive. There's no indication that she was a danger to the community or the highway, and there was no indication that she was under or over the legal limit. Now, how does that rise to stay out of trouble? Now, the officers, and Mr. Nelson just quoted again what the standard is for an arrest. That's a very low standard. Now, if Fitz knows that she's got a DUI pending, and, okay, let's see what she's doing, pulls her over. Now, did she get arrested because of what he saw in the field, or because she had another one pending? And that's the problem. It becomes a circular logic. Now, if the city wants to negotiate for no alcohol clauses, we do those all the time, but they didn't do that here. Now, what...
Well, that would make it pretty easy if we had that as part of the probation, but we don't, and I understand that argument.
Okay, well, that's routinely done. Now...
I know, I understand.
They didn't violate, she didn't violate that. Now, the police have this, we live in a linked age. The idea that the officer, the predicates that the officer's out there with his radio and by himself is not true anymore. He's linked in a network of data.
Your Honor, I apologize, I have to object. He's repeatedly said that the officer ran her scope before he pulled her over, and that's why she got a DUI. There's no evidence in the transcript of that anywhere.
Okay, well, tell me about that aspect of it. I didn't see it in there either, but I didn't say anything about that because I thought maybe I needed to reread the thing or something.
All right, Your Honor, the fact of the matter is the officer can arrest on very low standards. All right? When
Yeah,
an
but
officer-
an illegal turn is probable cause to pull somebody over.
Probable cause. Now, when he arrests somebody after they blow below the legal limit, then he takes her down to the station and she's below the legal limit, it is disingenuous to now come in and says, well, she should be violated. Well, the answer is why? The answer is routine. You say you've got to stay out of trouble, and the first thing the clients always ask, and it always says in court, well, how about a minor traffic offense? Oh, no, that doesn't count. Well, that's what this was. It was a minor traffic offense.
It ultimately could have been that or was that. I haven't heard from Ms. Halbert, but I don't doubt it. You end up pleading it out to that.
It's or failure to stop on a right
dealing with
vehicle
it that
full
way.
stop.
Okay.
Is a minor traffic offense. Now, the city's got to pick their poison. Now, the other thing is in just a few minutes ago, the city attorney, Mr. Jerbick, and I were arguing about whether they have the right to deny you an elected judge on minor traffic offenses. Now, just a few minutes ago, he was saying, no, you don't even get elected judge for these offenses. But here, the same offense that you weren't allowed to have a judge is being used to throw her in jail and activate the stay out of trouble order. And it's inconsistent. They need to sit down and roundtable their positions a little bit. But in this particular case, you read the declaration of arrest and you saw it was never going to lead to a conviction. Never. I mean, it was obvious when you read it. Look, well, this isn't a DUI case. It's an improper right turn. Now, this idea that the state can bootstrap or the city can go back and try to get what they didn't negotiate for, which is a no alcohol clause, that's improper. Now, every day they're in here screaming, or they're demanding that the defendants live up to their negotiation, and that's fair. Well, the city should live up to the negotiations. If they wanted a no alcohol clause, they could have gotten one. I'm sure they could have asked for it, but they didn't. No, I do not. I believe this is an abuse of discretion, and I believe it's fundamentally unfair.
Okay, I understand your argument. Ms. Halbert.
Your Honor, counsel states the correct standard of review, which is abuse of discretion, but then he essentially has a de novo or a sufficiency argument that he's telling me. He says, hey, Judge, you look at the facts. You look at the facts and tell me that it should have been different. He argues immensely about the fact that this was a DUI arrest and not a DUI conviction. That's completely irrelevant. And the lower court couldn't even consider that because the negotiations took place after the revocation hearing. Ms. Predmore was remanded. Perhaps that's the reason why the state, negotiated it down. We're not bound by the state. We're two completely different jurisdictions. And this court is obviously aware of the clear abuse of discretion standard set forth. And the two factors are, did the lower court apply the correct legal standard? And it's what this court said, was the court reasonably satisfied at the probationer's conduct? Judge Almasi specifically cited that legal standard when she rendered her ruling. She cited the Lewis case that said, the reasonable standard. That's an extremely low threshold. Mr. Mueller says, hey, it's to get arrested. That's a very low standard. I would submit to Your Honor that the reasonably satisfied standard is about as low as the arrest standard. They just have to be reasonably satisfied that her conduct was not as could have been. The second factor that the court needs to look at is the application of facts, whether it was illogical, implausible, or without support. Now, this is an incredibly high standard, and I don't know if Your Honor has had the opportunity to read U.S. versus Hinkson. I cited it in my brief. I don't think you necessarily need to read it for this one, but it is one of the most factually interesting cases that I've read in a while, and it talks about what an absolutely high standard of review, clear of abuse of discretion is. And quite frankly, I think that the only thing that's implausible is for Mr. Mueller to stand up and say, no, it's okay for her to get in the car and drive drunk again. He says, no, there's no evidence of impaired driving. That's completely inaccurate, Your Honor. My page 11
Well,
brief.
that gets to the heart of it, respectfully, in my view.
Okay.
Can a judge in a revocation hearing consider the alcohol use in the situation? That's really what it comes down to.
Absolutely. The judge has wide discretion in a probation hearing to consider whatever she likes, and as long as she applies the correct legal standard and the facts before her to that legal standard, the conviction or the ruling should be affirmed. And that's what the court needs to look at. What are the facts that Judge Almasi looked at? Not the facts that Mr. Mueller is saying speculate to. Hey, when anybody can tell when looking at this arrest declaration she shouldn't have been arrested, or this is what we got her later on. That's irrelevant. That was never before the court. That should never be considered. What the court needs to look at is what the trial court had in front of it. Trial court had in front of it this individual who 3 months after getting a submittal negotiation decided that it was okay to go to the Paris casino, consume 2 drinks, and then get in her car and drive home. And I can't fathom how somebody would believe that that was acceptable behavior under a broad state of trouble order. So unless your Honor is willing to find that Judge Almasi was somehow, illogical, or there was no facts in support of that, the conviction needs to be affirmed, or I'm sorry, the ruling needs to be affirmed.
All right, thanks.
My colleague did not articulate a condition of probation that she violated or a law that she broke. Now, there's a phrase that's not used to compliment. It's close enough for government work. Well, did you see what she did? Kind of just rub the facts together and hope you weren't going to be paying attention. Mm-hmm. She didn't break the law, and she didn't break a condition of her probation. She got a minor traffic offense. Now, officers make arrests all the time when there's not enough evidence to support even a finding of wrongdoing. Now, had they negotiated for a no alcohol clause, we wouldn't be standing here. She didn't break the law. She got a minor traffic offense. And the thought that she could have. No, law is about what happened, not what could have happened or what might have happened or what the officer suspected happened. The law is about what happened. She didn't break any new laws. She got a minor traffic offense. and she didn't break any conditions of probation. That is, in fact, an abuse of discretion.
I understand your argument. In this case, I'm going to give you a decision right now. Ms. Predmore, here's the way I see the situation. On August 8th of 2013, the municipal court dealt with what was essentially an admission or submittal to at least a DUI conviction. And in sentencing you on August 8th, 2013, the municipal court judge, as part of a probation provision, ordered that you stay out of trouble, and that was supposed to be, well, it would be for a year. So from August 8th, 2013 to August 8th, 2014, you're supposed to stay out of trouble. Now, if you don't stay out of trouble, then you would expose yourself potentially to having any of the stayed parts of the sentence sort of unstayed or put in place, including jail time or anything else that is stayed or that you're not having to serve because you're on probation. So the way I see it is, as someone who has been convicted of a DUI on August 8th, 2013, if a judge tells you to stay out of trouble for a year, or you might have to do some or all of the suspended jail sentence, you have to conduct yourself appropriately, knowing that you've been convicted of a DUI and you're supposed to stay out of trouble to avoid having to actually do parts of the suspended sentence. So then on November 21st, which is a little bit more than 3 months after the judge told you to stay out of trouble, it's evident to me that you were arrested under a suspicion of DUI. Ultimately, I think Mr. Mueller did a good job to cause that situation that occurred on November 21st to be resolved with a minor traffic conviction and not another DUI. So that's commendable. I think your counsel did a good job on that. Maybe it also is the fact that it was fortunate that you came up just below the legal limit, if there's something good to be said about all this for you. But in any event, here's the way I see the matter I have to deal with that as a backdrop. I do not think that a judge sitting in a revocation hearing is confined to the issue of what is the ultimate conviction following an arrest that might occur to a probationer. I think that rather that the judge can look at any relevant facts and circumstances surrounding the arrest. And so, though I appreciate your argument that you have suggested that the judge in the revocation setting, Judge Almasi, would be confined somehow to simply say, well, it's a traffic offense, and since it's just a minor traffic offense, it doesn't rise to some problem with staying out of trouble, I do disagree with that. I think as a matter of law, a judge sitting in a probation revocation hearing can look at any relevant facts and circumstances surrounding the arrest and consider them on the issue of whether somebody either stayed out of trouble or didn't stay out of trouble. In this situation, it's not lost on me, Ms. Predmore, that the probation stems from a DUI conviction. And so I have to say I agree with the city's position on this one, that it would be reasonable for the trial judge, Judge Almasi, to consider the issue of, well, within a little bit more than 3 months after I put her on probation for DUI, I have evidence that she's consuming alcohol and driving. To your credit, there was some admission that you had some drinks, but in any event, it's apparent to me that there was alcohol use and driving that was part and parcel of the arrest. Even though it ended up in a traffic violation, it is my view that Judge Almasi or any other judge sitting in a revocation hearing can consider those circumstances, including the alcohol use. And because of that, I just have to say, since the standard is did Judge Almasi abuse her discretion, I have to say there's no way in my mind that she abused her discretion in looking at, Ms. Predmore, your situation a little bit more than 3 months after you're out on a probation for DUI, seeing that you're drinking and driving again, there was enough evidence submitted to, in my view, to where Judge Almasi could have and did reasonably conclude that it was that you're drinking and driving, and though it didn't amount to ultimate conviction, I think that she could and did draw a conclusion, you know what? Ms. Predmore, you just weren't as good as I wanted you to be when I gave you the benefit of probation. And so because of all that, I think that the revocation hearing result should stand, and therefore the appeal of it is denied, the result of it is affirmed, and that means, Ms. Halbert, you can prepare the order. Okay, Ms. Halbert?
Yes, Judge, I'll prepare the order, thank you.
All right.
Next, we'll go to page 16. That's case number C-15